Hey folks, Bill O'Leary here, coming to you in this video, and I'm going to be addressing the question, what assets should be kept out of your trust? So, quick introduction, again, my name is Bill O'Leary. I'm an estate planning attorney and I do elder law and probate and deal with trusts as well. And my firm is Legacy Planning Law Group, located in Jacksonville, Florida. So, let's talk about a trust and the assets that should be kept out of a trust. So, a trust is a great way to make things go smoothly and easily to your loved ones when you pass away, because they will not be stuck in the court system, what we call the probate court. And so think of a trust as a box. A trust is a box. Well, it's great to put the box together to answer the questions: who gets your stuff, what they get, when they get, and how they get it, who, what, when, and how. But that doesn't complete the job. An important next step is getting your assets into the trust, into the box. What we call asset alignment. Other people refer to it as funding of a trust, aligning your assets with the trust. So that's a very important step that's often missed or overlooked, which then would cause that trust to fail down the road. Assets we can put into a trust. A house is a great example. You've got the bank account, maybe you've got the investment or brokerage account. But there are some assets that we don't put into a trust for different reasons. A big one is a retirement account. Think IRA, 401k, that sort of thing. We don't put it into the box. We don't retitle the ownership from you into the name of your trust, because doing that would have a very bad tax effect. It would cause an immediate liquidation and tax event. So we don't do that. Another asset that we do not retitle into the trust, an annuity, and the third biggie is life insurance. However, we don't ignore those assets. So with respect to getting the trust put in place correctly, asset alignment, aligning your assets with the trust, we'll look closely at what are called beneficiary designations for those types of assets. We can designate a beneficiary. So it may be that instead of designating an individual person as a beneficiary of that financial asset, we may designate the trust to have it paid to the trust at death. So again, it remains outside of the trust while you're alive, but it can go into the trust at your death. Now, I want to go back to the bank account or the brokerage account. Well, that kind of thing can be put into a trust for sure. And let's say the trust is put together by a married couple, and that account is owned jointly. Well, we can go ahead and move it into the trust, no problem. There's no tax impediment to doing so. However, we would lose valuable asset protection by doing that. So how do we maintain that asset protection? Think one of the spouses gets into a car accident, it's their fault, here comes the plaintiff's lawyer. How can we continue to protect that jointly held marital in a bank account or investment account with a trust in place? Well, what we might do, depending on the situation, is say to the client, hey, keep that account jointly owned. Don't change the ownership, but let's have it paid into the trust at the second spouse's death. So you're out on date night, let's say you don't make it home. You know it's going to end up in the trust, flow through the trust, flow through the box the way that you want, but while you're both alive, it's given the best protection possible. Last asset I want to talk about, vehicles. So do you put a car into a trust? No, I do not like putting a car into the trust, okay? For this reason. There is no upside to putting a car in a trust, and there's potential downside. The no upside. You do not need a trust in order to pass a car at death easily outside of probate, because DMV already has rules in place to solve that problem. So you don't need a trust to do that. No upside. There is potential downside. Think that you have a car, retitle it to a trust, you get into a car accident, here comes the plaintiff's lawyer. They're going to figure out pretty quickly that a trust owns the car. Well, when people hear the word trust, what do they think? Money. So it changes the complexion of that legal matter altogether. I think increases the settlement's value that they may put on the case. So it has potential downside. No upside, potential downside. So unless you have like a collector's item or an antique car, if it's your regular transportation vehicle, don't like putting a car into a trust. So hey, want to go ahead and invite you to go ahead and to subscribe to our YouTube channel to find out more about this and other similar topics. Legacy Planning Law Group. Just go ahead and click on the link at the bottom of this video. It takes you right there. Also, if you want to go ahead and find out more and maybe how we could help, go ahead and reach out. Schedule a free 15-minute discovery phone call. Again, go to the link at the bottom of this video and just pick a day and time that works for you. So, Bill O'Leary signing off for now. Go make it a great day and a better world.